One of the biggest ways Windigo economics is impacting Indigenous peoples today is through the oil industry. And there are so many different examples of this, from the Dakota Access Pipeline in the Ochete-Sakowin territory on Turtle Island here in North America, the Ogoni in Nigeria over in Africa. And I want to look today at Texaco, Chevron, and the Indigenous peoples of Ecuador in South America. Pretty much what this is going to be is a look at some key developments in the lawsuits that have been going on between the Indigenous peoples of Ecuador and their suing of Texaco Chevron or Chevron Texaco. And it's to accompany the movie Crude that was done by, or features, the lawyer Donziger that represented the Indigenous peoples of Ecuador. So, as I will have probably said in my introduction to the film, I think it's a good film in terms of how it looks at the environmental impacts of the oil industry in this region of Ecuador on the Indigenous peoples there and on their land. I feel it focuses a little too much on Donziger's story, but it might be understandable, as you'll see by the time we're done taking a look at this whole situation. But yes, I would prefer that it stayed focused on the native peoples of the region. But I think it does a good enough job of bringing their stories to light, even though I would like to see it a little more brought out. So let's take a look at some of these dates. And like I said, it's pretty much just taking a look at key dates and developments in the lawsuit, which may sound boring, but turns out to be kind of jaw-dropping because it's crazy, the stuff that happens. All right, so you ready? First of all, I'd like to point out that where we are talking about is Ecuador here in South America, in the yellow circle, which is in the northern part of South America, and we are taking a look at the Lago Agrio region in particular, with Chevron and the oil industry's impact on Indigenous peoples. In 1993, the Indigenous communities of Lago Agrio, Ecuador, sued Texaco, which was the oil company who had conducted oil operations in their homeland and that they were alleging had caused oil contamination in their homeland. Lago Agrio sued Texaco in the United States in New York state courts under the Alien Tort Statute. And Lago Agrio was charging Texaco with dumping billions of gallons of toxic oil waste onto their homeland and into their waterways, causing a poisoning of the land and thus a poisoning of those who lived off the land, including the Indigenous peoples. The Alien Tort Statute is a statute from 1789 that allows foreigners access to American courts, and it had to do with the American Revolutionary War around the American Revolutionary War time period, and after the United States had formed, and there were diplomats who had come over from other countries, and if a crime was committed against them or what have you, it was a way of giving them access to the American court systems. After a while, I think it largely just kind of was a forgotten statute until about the 1960s, 1970s, when human rights lawyers brought it back up again and saw that it allowed for people from other countries to access the United States courts in order to hold people, corporations in particular, accountable for human rights abuses when those people were in countries that they didn't feel they could get a fair hearing. Like perhaps they were living in a country that had a corrupt government and was working hand in glove with a corporation that was causing these human rights abuses of Indigenous peoples. The United States and their Alien Tort Statute gave people access to the court system to hold those corporations accountable. And that held up for several decades under American law, that this was an acceptable legal way to use the court systems. It's also something that's permissible under international law, because international law does allow nation states to uphold international law through their court systems. In 2001, Texaco merged with Chevron when Chevron purchased the Texaco Corporation. And so this merger becomes known as the Chevron Texaco Corporation. Chevron bought Texaco for $36 billion. Once Chevron acquired Texaco, it argued that the United States did not have the jurisdiction to hear the Lago Agrio case against Chevron. So Chevron argues within the U.S. courts that American courts did not have jurisdiction over this particular case that it had inherited when it purchased Texaco, and therefore the case should be dismissed from American courts and be heard, Chevron argued, in Ecuadorian courts. In 2003, Chevron wins this argument in U.S. courts, and the trial is removed from the U.S. court system and recommences back in the Ecuadorian court system, which is what Chevron wanted because it felt it would get a more favorable hearing in Ecuador than it would in the United States. In terms of how it was going to get that more favorable economic hearing, perhaps some light is shed in 2008 when Chevron lobbies the Bush administration, this is President George W. Bush, a Republican president, to remove trade preferences for Ecuador because the Ecuadorian courts were not looking as though they were going to decide in favor of Chevron. So Chevron lobbied the Bush administration to remove American trade preferences for Ecuador in order to pressure Ecuadorian courts to decide in favor of Chevron in the Lago Agrio case. In 2011, despite this pressure, the Ecuadorian courts decide against Chevron and in favor of the indigenous peoples of Lago Agrio, and they decide that Chevron shall be held responsible for the pollution that was caused by the company they purchased, Texaco, and therefore Chevron was responsible for paying Lago Agrio $9.5 billion in compensation and damages. This is the first time known that indigenous people sued a multinational corporation in the country where the crime was committed and actually won. Usually when indigenous peoples sue corporations in the crime in which it was committed, i.e. their own, the colonial government that has taken over their lands and is working with corporations who are taking over indigenous peoples' lands, usually indigenous peoples lose, or had up until this point lost, when they use the court systems of the colonial system that has colonized their particular homeland. But in this case, Ecuador decided in favor of the Lago Agrio indigenous folks, and Chevron was found responsible for the oil contamination in the area and fined $9.5 billion. By comparison, the largest environmental settlement in United States history was the 2015 Deepwater Horizon settlement with British Petroleum, or BP, in which BP was ordered to pay over $20 billion in damages for what it did to the Gulf of Mexico coast and the waters there. So this is $9.5 million. It's coming up pretty close to that large of a fine too that BP received in 2015 for the Gulf of Mexico, Deepwater Horizon. Chevron now was charged by Ecuadorian courts for paying indigenous peoples in Ecuador $9.5 billion in damages. Chevron's response in 2011 is that the ruling of the Ecuadorian courts is, quote, illegitimate and unenforceable, unquote, and Chevron refused to pay the fine. In order to force Chevron to pay up for what the courts had found it responsible for, the Lago Agrio villagers have to continue to sue Chevron, and they sue Chevron in the countries where it has assets, because by this point in time, Chevron no longer has assets in Ecuador. There is nothing that the Ecuadorian courts can seize that belongs to Chevron in order to, take their assets and turn it over in order to turn over that $9.5 billion from Chevron to the indigenous peoples. Ecuador has no access to Chevron assets because there are no assets of Chevrons in Ecuador. So in order to get access to those assets, Lago Agrio villagers sue Chevron in Canada, Brazil, Argentina, and the United States, and their lawsuits are arguing in those court systems that they're asking those national court systems to freeze Chevron's assets in those countries in an attempt to collect the fine Chevron is responsible for. So I want to take a brief look at how this played out in Canada and the United States. I can tell you right now that with Brazil and Argentina, both of those countries turned down the Lago Agrio case in terms of meaning they decided against the Lago Agrio people and did not freeze Chevron's assets in either Brazil or Argentina. But there's some interesting developments that happen with the United States and Canada.